You. Good afternoon. This is really a pleasure. It's the first of our big community events of the fall, and it's really nice to see so many of you here. Really a joy to get to be together around such important topics as the ones that we're going to discuss today. So I just really want to welcome all of you here, both those of you who are students here, obviously our faculty and our staff, and also we're joined today by members of the Bloomington Rotary Club, and I'll say just a little bit more about that in a few minutes. But really welcome everyone to the law school, whether this is your daily home or the first time in the door. We're really glad you're here. Thank you. So as many of you may know, federal law requires institutions that receive federal funding to hold educational programs around Constitution Day, which is September 17th. The Constitution was signed in 1787, and we are celebrating that day today. And we do that through our compliance with that federal obligation, but we don't do it as a box-checking exercise. We do it really as a moment to come together, both to celebrate the amazing achievements of the Constitution that has formed this democracy, and also to recognize that it is constantly a work in progress. And we know that today in a very poignant way. We know that we've got some very contested issues around the Constitution. And so in a moment like this, it gives us an opportunity to really focus and be together around some of those issues. So I want to also just extend gratitude. I'm very deeply grateful to the people who brought this event together today. So I want to thank Steve Sanders, who is the faculty advisor for the American Constitution Society, Tim Waters, who's the faculty advisor for the Federalist Society, Gabriel Escobedo, who helped very much with the student groups part of the planning, and obviously our amazing staff. So I'm thinking here of Chelsea Browning, who makes everything run smoothly and beautifully, James Boyd, who makes sure that we all know about events ahead of time and also know about them after the fact, and our incredible tech team, who I was waiting for when I was looking back there to see whether we are live. It used to be that we had a video camera at the back of the room, and so it was very visible, but we just got really great updated technology, and so now it's all remote, and so I was waiting for the go from them. So here we go. This event, in addition to being an opportunity to talk about and celebrate the Constitution, it is a tradition here at this law school. We both around Constitution Day, but also more generally, engaging important and contemporary legal issues, even when they are challenging, and especially when they have opposing viewpoints. We like to bring people together to help us see the robust picture around a challenging legal issue that our country is facing from a variety of perspectives. And we do that because we know that as lawyers, dialogue around those hardest issues is possible. And if anyone can do it, we can do it. And if anyone can model it, we can model it. And so this is a very important tradition here at the law school. It's the only way we arrive at truth. And even if we can't get to truth, a unified, agreed truth, at least we can get to better understanding. And through that better understanding, we build a stronger community, a stronger state, and a stronger nation. And so it is at the core of what we do. It is critically important. That's why we've invited today the Bloomington Rotary Club to co-sponsor this event alongside the American Constitution Society and the Federalist Society, because we know also that what happens inside this law school can make our community stronger. And so I'm really grateful to Jeff Richardson, who's at the back of the room, who helped to bring the Bloomington Rotary Club into partnership with this event. Thank you so much, really, for your friendship and that effort. And then just really quickly, before we begin, I want to just make a quick announcement that Chancellor David Reingold here at the Bloomington campus is initiated a 250th anniversary commemoration of the Declaration of Independence with a year-long series of events that is highlighted by a centerpiece exhibit that will be featured at the Lilly Library's rare copy of the Declaration of Independence. And so just keep an eye open for all of the tremendous events that will be happening around that celebration. So now, just to get us started, please join me in welcoming our student leaders of our two student organizations, Delaney Lynch, who's the president of ACS, and Sarah Powers, who's the president of FedSoc. So they will introduce our two fabulous speakers, and I will leave that job to them. So Delaney, if you can join me up here, the floor is yours.
Good afternoon, everybody. My name is Delaney Lynch, and I have the honor of serving as this year's American Constitution Society president at Maurer. It is my privilege to introduce our speaker, Professor Trammell. He earned his law degree from the University of Virginia and, after graduating, clerked on the D.C. Circuit and the International Criminal Tribunal for the former Yugoslavia before practicing litigation in D.C. He is now a professor of law at Washington and Lee University, where he teaches and writes about civil procedure, federal courts, and constitutional law. His scholarship in these areas, including his influential work on universal injunctions, has appeared in top law reviews and leading casebooks. We are fortunate to have him with us today to help us think more deeply about the role of universal injunctions in our legal system.
Good morning, y'all. To those who don't know me, my name is Sarah Powers, and I am this year's president of the Maurer's chapter of the Federalist Society. So we are joined today by Professor Brad Jacob. Professor Jacob is Regent University School of Law's Associate Dean for Academic Programs and has been a professor at Regent Law since 2001, specializing in classes such as constitutional law, criminal procedure, and nonprofit tax-exempt organizations. Professor Jacob began his career with the major international law firm DLA Piper and has since worked as a staff attorney in the Center for Law and Religious Freedom, executive director and CEO of the Christian Legal Society, founding provost and dean of Patrick Henry College, and director of the Justice Policy Institute at Prison Fellowship Ministries. Please join me in welcoming both Professor Trammell and Professor Jacob to this event today.
Well, thank you all. It is our delight to be here today. If you're expecting that this is ACS and FedSoc having a knockdown, drag-out, screaming insults, you're in the wrong room. As Dean Trammell and I have talked and planned for this, we have perhaps some areas of disagreement, but a lot of areas of agreement. And we're here today to do what I wish more of America was doing today, which is having collegial, courteous, respectful conversations about issues instead of screaming invectives to one another. So this is good. It's my pleasure to be here, especially as I mentioned to the dean. My father was an alumnus of this law school, class of, I think, 1949. Yeah, it was a little while ago, but he never got over Bobby Knight not being the basketball coach anymore. So here we are. We're going to talk about universal injunctions. I think it's important to note that we're talking universal injunctions, not nationwide injunctions, which is how the issue is sometimes characterized. Any injunction can be nationwide. If there's a lawsuit involving Amazon.com and the federal government and it binds those parties, well, Amazon is nationwide. That's going to apply all over the country. The trick with the universal injunction is that it applies to parties or to people or organizations, institutions who are not parties to the lawsuit. Can you be bound by an injunction if you weren't actually represented in the litigation? This has become a very hot controversy. It's not actually that new. It's been percolating at least since the Obama administration. President Obama, for example, used the DACA executive order to deal with the Dreamers, which I hope we all are sympathetic with what he was trying to do, but he famously told Congress, I don't have power to do this, you've got to pass a statute. So they didn't, so he did it with an executive order. President Trump comes into office and he starts doing a lot of things with executive orders. President Biden comes in and he has a few of his own. Student debt forgiveness comes quickly to mind. And then President Trump comes back in and is trying to set historic records of solo presidential action that is at least arguably illegal and unconstitutional. So in the last couple decades, this issue has just exploded. Part of what's a little bit entertaining is that most people flip-flop in how they view the issue. When it's, President Biden is in office and the Republicans are filing these lawsuits, then the Republicans think that universal injunctions are wonderful, and the Democrats think that they're destructive of the democratic way. And then President Trump is in, and everybody switches sides in how they talk about the universal injunctions. So the politics of this is pretty hypocritical on the whole, not very principled, and hopefully we all, as lawyers and future lawyers, recognize that it's usually, the most important question is usually not what did you accomplish, but how did you get there? What does the process look like? Because whatever process my side has, the other side will have sooner or later, and it needs to work. So the case that is particularly bringing this to our attention today was called Trump v. Casa. Trump v. Casa involves the question of birthright citizenship. Section 1 of the 14th Amendment says that all persons born or naturalized in the United States and subject to the laws thereof are citizens of the United States and of the state in which they reside, subject to the jurisdiction thereof. And through most of our nation's history, it's been pretty well accepted that the people who are born in the United States and do not get birthright citizenship is a very narrow class, typically diplomatic personnel. If the British ambassador in DC, or the ambassador's wife, if the ambassador is a man, goes into DC General and has a baby, that baby does not become an American citizen because the diplomats are kind of considered as living in their own little chunk of their home country. Theoretically, if an invading army was on our soil and someone gave birth, that person would not get birthright citizenship. Thank God that's not something we've had to deal with in our nation's history. But most of the time, there's been a fairly strong consensus, but never universal, that anyone else who gives birth on American soil is an American citizen. There have always been a few who argued, well, if you entered the country illegally and gave birth, the 9-month pregnant woman from Central or South America who finds a place where there's no wall and crawls across the border and gives birth on American soil, is that baby an American citizen? Again, most folks who've looked at this would say yes, but there have always been a few who would argue no, because the woman was intentionally not subjecting herself to the jurisdiction of the United States when she entered illegally, and therefore she's not subject to the jurisdiction, her baby is not subject to the jurisdiction. There's at least a little bit of room for debate there. President Trump issued an executive order saying the babies born to illegal immigrants or to people who are in the country on short-term visas are not birthright citizens. He purported to answer the question in the executive branch, and that raises a lot of issues. Does the president have sole authority to decide that question without involvement by the courts, without involvement by Congress? Maybe the president's interpretation is right, but a lot of people think his interpretation is wrong. What do you do with that? The Trump v. Casa lawsuit was challenging that interpretation on the behalf of people and organizations representing people and states who had folks who they thought were citizens, who came in and were born in this country of, let's say, illegal aliens, just to, or non-documented, whichever. I actually don't think either term is terribly accurate, but people who did not follow normal immigration procedure when they entered the United States. So this is the lawsuit that was filed. The Supreme Court decision, however, had nothing to do with that issue. And I tell my con law students, they're very excited about all the stuff that's happening in Washington politics and the Supreme Court. And the reality is there are very few substantive decisions on these issues yet. It hasn't had time to play out. So most of the law involving President Trump has been off of what some call the shadow docket. I think that's pejorative, or the interim docket, or the emergency docket, or I kind of like equity docket because it usually has to do with temporary restraining orders or preliminary injunctions. figuring out how do we preserve the status quo while the litigation is going forward. And that's what Trump v. Casa was. And you have a federal district judge issuing an injunction that purports to stop the United States government from enforcing the president's executive order about birthright citizenship, not only against the parties to the lawsuit, but against everyone. And the Supreme Court gets this on its expedited docket, its emergency docket, to answer this question. Did this one federal district judge have the power to enjoin everybody in the country on an issue that the president has spoken to? And it gets to the Supreme Court, and the Supreme Court, not surprisingly in a divided opinion, but the Supreme Court gave a decision that initially was read as they've simply struck down universal injunctions. Is this a great separation of powers constitutional issue? It really wasn't. It was a statutory issue interpreting, of all things, the Judiciary Act of 1789, and saying that that gave district courts common law, equitable powers, and under the common law, injunctions only applied to the parties to the litigation, and therefore district courts couldn't do it. But the court, as people have looked at the decision since, the court left open a lot of other ways that we may still get to the same place. And indeed, the court, in deciding Trump v. Casa, issued an order to preserve the status quo of its own decision. So it was essentially claiming some universal injunctive power for itself, even at the same time that it denied it to federal district courts. So I don't know, we can maybe hold off on the other routes to get to the same place. But that's essentially what happened with Trump v. Casa. Not a decision about birthright citizenship. We'll get that sooner or later, I'm sure. Not even really a constitutional decision, except at the broadest, most conceptual level, but saying this is how we read the equitable powers of the federal district courts. But that's what's pushed this thing back into the national conversation at this point.
So let me make just a couple of observations, and I agree with this characterization. This is a microcosm in a lot of ways of how the Supreme Court is approaching the current administration and the current political moment. You have this big issue, question of birthright citizenship. What does the 14th Amendment, arguably the most important amendment to our Constitution, what does it mean? Does the President of the United States have the authority to almost unilaterally rewrite the settled understanding of the 14th Amendment? A reading that has existed since the Supreme Court decided Wong Kim Ark in 1898. And President Trump comes along and says, I'm going to change this. So it's this big picture issue, and yet the Supreme Court granted certiorari only on this narrow interim remedial question. We see this in a number of other contexts as well, whether we are talking about immigration issues, whether we're talking about sending individuals to SICO in El Salvador. You've got the various cases also coming off of the emergency docket, the shadow docket, whatever you want to call it, JGG, AARP, these issues that are huge. And yet the Supreme Court purports not to decide the actual issue. It kicks the can down the road, but it says we're going to decide a scope of injunctive question, scope of injunctive relief question. We are going to decide whether a class action is proper or whether you needed to proceed in habeas. We're going to decide that you can't proceed in Texas or that you can't proceed in DC, that you have to go to Texas. These seemingly small bore, the smallest bore procedural questions. And yet, when you start to view them as a whole, they really begin to shed light on the latitude that the Supreme Court is giving to the Trump administration. I think back in a lot of ways to some of the decisions that came out of the early 2000s during the War on Terror. This is where I date myself. This is when I was in law school, pretty much immediately after September 11th. And you saw the Supreme Court intervening, but only at the margins, only years after the fact. And yet, it was really shifting the balance of power, and in a lot of ways, I would submit, set the tone for where we are today. You can trace some of this back to World War II, also during wartime, when the Supreme Court was not necessarily doing its best work, when it effectively condoned the internment of Japanese Americans. So this is not a new phenomenon, but I think that it provides some really, really important context to our political moment. And what we've talked about is that we want to broaden this conversation out and to ask, all right, well, what is the role of the judiciary, and in particular, what is the role of lower courts in an American democracy? How do we navigate the tension that has existed by design since the inception of the Republic? This tension between the elected political branches that are supposed to do the bidding of a majority of us, and the role of a constitutional democracy and the role of courts in enforcing this document. So before we get too broad, I want to ask if there's anything about universal injunctions that you think should have been saved.
Well, it's hard to answer that without going out to the
Well, go ahead, take it out then. Yeah.
macro level.
Yeah.
We fundamentally in this issue have the tension between should one federal district judge be able to change policy for the entire country. There may be cases, now this wasn't true with birthright citizenship, but it could be a case where the president and Congress have together taken a position, and maybe it's been challenged in courts all over the country, and maybe there's lots of decisions. Maybe in 8 of the circuits, they've gone one direction. But if you can find that one federal district judge who's inclined to go the other way, and of course Republicans always file in South Texas and Democrats always file in San Francisco. That's just kind of how it goes. You know your culture. You know where you're. There's even a few single district federal district courts that you can, if you hit the right court, you can almost have certainty. I know who's going to hear my case and whether this person is sympathetic. If you find that one federal district judge, all these courts of appeals have gone the other direction. But if they're not his or her circuit, it's not binding, right? It's heavy weight of precedent, but it's not binding precedent. So you get this one person who's essentially saying, no, they're all wrong. Every one of them is wrong, and therefore I'm going to enjoin everybody everywhere on this policy. That's the one side. But the other side is, what do you do if the government is doing something that's out of control? What do you do if the president or Congress or somebody is acting in a way that really is unconstitutional, violating people's rights? What's the result? If I'm a citizen and that I know it's wrong, what action can I take? About the only thing I can do is go file a lawsuit in federal district court, and even that I've got to prove standing. And anyone who, if you've looked at standing doctrine, that's not always easy to do. But what else can you do? And now you're the federal district judge. If you sincerely believe that this is just wrong, if you sincerely believe, President Trump is wrong saying that someone who enters the country without following immigration procedure and gives birth, saying that that baby is not a citizen of the United States. If you believe that's just wrong, what's that federal district judge supposed to do? And that's really the tension.
Yes, and I think that what you're teeing up, and something that I have always agreed with since I've been writing about this, universal injunctions are an extraordinary remedy. We'll talk, if we have some time, about other kinds of extraordinary remedies that have developed over the last century, call it, but really in particular since the 1960s. Even though I've written in defense of the constitutionality of universal injunctions, I've always argued that they truly should be rare, and that district courts, especially early on in the Trump administration, were perhaps too reflexively saying the Trump administration did something not just wrong or illegal, but really wrong and illegal. And therefore, we need an extraordinary remedy to put a halt to it. So with that in mind, what is the way that this litigation is normally supposed to play out? What is the normal way that we mediate that tension? If, for example, you are a citizen, you're deleteriously affected by a particular policy, and you want to essentially take it to court. How does that normally play out without the extraordinary remedies that we're talking about?
Well, I'm not a litigator, so you're gonna stretch me a little bit, but I would assume the normal procedure would be I would get an injunction about what the government can do to me,
right?
And say no, you can't make Jacob do this, but it would not reach the whole world, at least not unless it gets up to the Supreme Court and gets affirmed, and then it becomes binding on everyone.
Right, and so that is indeed the normal way that this works, that each individual is allowed to go into court. But while my lawsuit or your lawsuit is pending, the presumption of regularity says we are essentially going to give the administration the benefit of the doubt while the litigation is pending. That is to say, usually the government is going to be able to continue enforcing its policy, continue enforcing it against essentially the rest of the people in the United States who've not sought an injunction. And again, they get the benefit of the doubt. I have to essentially prove my case. And that's true even when the political branches might be pushing the envelope a little bit, but when they're doing so in good faith, they do get that presumption. Yeah. There's a sense that these extraordinary remedies, of which universal injunctions are just one, can become most appropriate when you see recalcitrance on the part of the government. So one of the things that I've tried to hark back to in terms of understanding the kind of moment that we would want to identify that would justify the flipping of that script, if you will, would be the period of massive resistance in the South during the desegregation battles. You had state governments and local governments that weren't just pushing boundaries. They were openly defying the Supreme Court and the iconic case of Brown versus Board of Education. They were actively looking for ways to avoid their legal obligations. And without getting into too much centuries-old history here, that was the role of equity back in England. Equity was supposed to step up and fill the gap when remedies at law weren't sufficient. Again, the normal remedies at law would be I would bring my lawsuit, but when the government, the people supposed to be doing our business on our behalf, actively tries to avoid its legal obligations, equity can get creative. Now that can get dangerous. It can be abused, but that is traditionally what we think of as that gap-filling role of equity. So the question then arises, I think, are we in that kind of moment? And not just in the abstract, but are certain cases presenting the situation where the government is actively trying to avoid its legal obligations, where it's trying to get around clear, settled precedent? And if that's the case, arguably, district courts should be getting involved. Even a single district judge, Jeff Sessions, when he was Attorney General, very infamously derided a judge on an island in the Pacific, never mind that that island is the state of Hawaii, which is part of the United States, and that this was an Article III judge. Leaving that aside, there is this sense that one lower court judge could have this awesome power to, on his or her own, say, I have identified this egregious situation that merits my intervention on behalf of the entire United States. And as Dean Jacobs said, there's a sense in which when that judge is on your team, you're cheering the judge on and you're saying, this is justice as we know it in America. When the script gets flipped, it is a travesty. It is the degradation of all constitutional democracy. So the rhetoric does tend to get heated, and there's a sense in which we can feel very proprietary about the actions that we support. But it's tough to identify, even if in theory you support what I'm saying, it's tough to identify the scenario in which we truly are in extraordinary times or where there is an extraordinary case that merits that kind of aggressive intervention.
This is probably where I, as the FedSoc speaker, am expected to jump in and say, no, President Trump is totally normal, business as usual. I'm sorry, Sarah, you got the wrong speaker. Whether you agree with President Trump's objectives or not, he is very clearly a president who believes that he's got to get things done, and he's not much concerned about the process issues. I mean, if you're going to try to say we're going to criminalize flag burning, you haven't taken even a college con law course. You've really kind of missed the boat on a lot of things. So this is an extraordinary time. It does make these issues just raise to a level we haven't seen before. We're not in normal politics, and again, I'm a pretty old fellow. I'd been practicing law for a long time by the 2000s, but this is not the world I lived most of my life in, and to some extent on both sides. But certainly the president is a dramatic example of this. We've got this collision where people are not willing to just debate and discuss and heaven help us compromise and try to do what's good for the country. Instead, we have to just fight for whatever we think we can get done. And absolutely, the president is guilty of that at a very high level. I think another thing that's worth noting is this whole problem could easily be resolved if Congress was functional. Yes. One of the biggest problems we have in our country today is that Congress has become performative, and no one is interested in doing the work of legislation, which involves debate, negotiation, and that word again, compromise, because both sides have now said, we will not compromise. We're tougher than anybody else. We will fight to the death for every jot and tittle, everything that we want to have. You could write a statute fairly easily, and I haven't given this a lot of thought. You've probably thought about it a lot more than I have. Congress could pass a statute saying, if you go into a regular federal district court and want an injunction, that injunction can only apply to the parties to the litigation. If you believe that this is such a national emergency that requires a universal injunction, we could create a special federal court, a multi-judge court. You could require that some of the judges be of the different political parties to make sure it's not controlled, by one side or the other. You could have a special appellate, an expedited appellate process where that goes to the federal circuit or, but get it up to the Supreme Court fairly quickly. You could write a way to do this so that we would no longer have to worry about the rogue federal district judge to have a better process. But Congress doesn't do it. And again, it depends on who's in the White House, but one side or the other is not going to agree to any policy like that. They're going to say, oh, I hate that president. I want these district judges doing what they're doing. And then it flips around and now the other side says, no, I don't want to. You know what I'm saying? This is such an easily solvable problem if our Congress and our political system wasn't so horrifically broken.
Let me agree with half and disagree with half of that.
Okay, that's fair.
The half
that's more than my wife agreed with.
The half that I agree with is that a large part of the reason why we are where we are is because Congress has become almost completely subservient to the president if they're from the same party, or Congress views its job, if it's in opposition, not to be the loyal opposition, but to throw the brakes on the entire workings of the federal government. I'm painting with too broad of a brush here, but in very, very general terms, it seems that that is how Congress views its role. So if Congress and the president aren't working together, if they're not really legislating, if they're not doing the hard work of figuring out how to make the big decisions on behalf of a big, boisterous democracy, then who does it? It's administrative agencies, which are largely becoming hampered because of decisions by the Supreme Court on the administrative state, and it's judges. And judges will be among the very first people to tell you, we are not the ones who can craft legislation. We're not the ones who should be making these big picture decisions. And yet, when parties through very sophisticated lawyers style their arguments in these constitutional terms, judges ultimately have to make those decisions. And there's another piece of this that contributes to the phenomenon, which is that the Supreme Court decided the case of Massachusetts versus EPA in 2007. And that more or less said that states have an easier time getting into court. Again, I'm generalizing, but if everything else is hamstrung, If Congress and the president aren't working together, if individuals have trouble getting into court because of standing problems, states can do that. And so you see this whipsawing from presidential administration to presidential administration. When Barack Obama is president, you have red state attorneys general who are lining up to go to the Fifth Circuit and file their challenges to the deferred action programs of the Obama administration. Flip the script. President Trump is in power. It is the blue state AGs who are rushing off to the Ninth Circuit, potentially to the First Circuit, to try to challenge those policies. And so it has all had the effect of relocating the locus of these debates away from the political arena where arguably many, if not most, of the debates should take place. Here's where I disagree. Even if Congress were really functional, I don't think that Congress is in a position to say, well, this is the panacea that we need. A number of times I've been asked since the Supreme Court decided CASA, is this really such a big deal? And I've said, in one sense, no. Actually, in two senses, no. First, the Supreme Court didn't actually decide the birthright citizenship question that seemed to be the headline item. Number two, the Supreme Court, as Dean Jacobs said, did not couch this in terms of the Constitution. When this debate really started in earnest about a decade ago, you saw a lot of people arguing, including President Trump's first Justice Department, these universal injunctions are unconstitutional under Article 3. They violate the case or controversy requirement. And then there were the challenges under the Administrative Procedure Act. And so a lot of the people who would say, well, they're unconstitutional would say, but the APA is different. And I would think, how can you have an unconstitutional statute that is providing this workaround? Justice Barrett, former law professor, squared the circle by saying, well, we're rooting this in statutory interpretation. And if Congress wants to, it is allowed to provide for this mechanism. And in a lot of ways, Congress already has. We have class actions, including injunctive classes. We do have the APA, at least as I am reading some of the opinions in CASA. The Administrative Procedure Act is going to provide a very potent mechanism for a lot of these issues to be adjudicated. So if you're asking a really small bore question, can you get very broad relief on behalf of people who are being wronged by the government? In theory, yes, there are these mechanisms. The difficulty, where I say that Congress actually can't solve all of these problems, is that equity by its very design is meant to be flexible. And when you have people who are behaving in bad faith, think about school boards in the South during massive resistance, they are devising these diabolical ways of getting around their legal obligations. And in some ways, courts necessarily have to be reactive to that, and they have to have a certain amount of creativity in responding to adventurous lawlessness. Sorry, I'll get off of my soapbox now.
And I don't disagree with any of that. I do think Congress could improve the situation, but you're right. The nature of equity is such that it needs to have some level of flexibility to deal with changing circumstances. I also just want to, I don't want to get too wonky, but Massachusetts versus EPA, a lot of us read that as saying, wow, the court is giving carte blanche for states to have standing and bring lawsuits. But you may recall one of President Trump's attempted lawsuits, or his allies in Texas tried to file a lawsuit challenging, was it Missouri's? Challenging another state's electoral votes after the 2020 election based on...
Pennsylvania's, I think, right?
Was it Pennsylvania? Okay.
I forgot.
Based on that Massachusetts versus EPA special solicitude when a state requests standing, and the Supreme Court wasn't going to go near it. So, you know, the court, we're lawyers. We deal with words. If you want absolute precision, go to accounting school. You know, you're in the wrong building. If you know, words can be malleable, and sometimes you think, well, that's a clear answer out of the court, and then they couch it and they spin it a little bit. And states, I think, are still given some level of solicitude, but maybe it's not quite as broad as we thought back when the Massachusetts case came down.
We are law professors and could talk until sunset, but we wanted to allow good 15, 20 minutes for you all to ask about what you're interested in hearing about and exchanging some ideas. So I think it makes sense to go ahead and open it up. And again, we're law professors. We can cold call if there's not enough engagement here. Steve.
I'm a law professor, but I'll get the ball rolling. So kind of separate from the issue of universal injunctions, you, either or both of you, see a serious problem with the populist nature of our politics today and the appeals to populism, making judges more hesitant to rule in a way that they believe is necessary to rule on principle because fear of attacks from political leaders, fear of potential physical danger to themselves. So again, aside from the particular universal injunctions issue, is there a threat to judicial independence and autonomy in the political times we live in?
I mean, I think absolutely yes. I don't think it's entirely the populist movement, though. That's certainly a huge part of it, but I think our entire political culture has become so toxic. I mean, you look at what we've seen in the last week or so since Charlie Kirk was murdered, and you've got people on the right saying, it's them, it's the left, they all want to kill all of us. And you've got people on the left saying, well, these crazies on the right, they've sown these seeds and now they're getting what they planted. And again, the people who are willing to support process, to support the judicial system, that's not everybody anymore. And if I were a federal judge or a state judge, I'd be very concerned about what sorts of things I could say and what sorts of ways I could rule, because I think there's a potential on either side. The climate is, there's always going to be crazy people. There's always going to be people who don't recognize ethical, humane norms. But I think the political climate we're in gives those people a huge excuse to act on their fantasies or whatever it may be.
I agree with that, and I think the only thing that I would add is that law is in some ways an inherently conservative, small c profession. We are taught to operate within the realm of certain rules, and that includes judges. And almost all district judges I know are extremely conscientious people. I might disagree with how they come down on a particular decision, but they are deeply cognizant of their role, and they understand that they are not supposed to be, quote unquote, legislating from the bench. They all understand this. The question then is, when you're dealing with extraordinary situations, when you're dealing with a president who in a lot of situations basically says, I don't care what the law is, I'm going to do what I want to do, how are you as a judge who has been taught to operate within a fairly narrow sphere supposed to respond to that? And I think that there is, for one of the first times in recent memory, a genuine concern on the part of the Supreme Court that the political branches might simply not obey what the Supreme Court says. That's a situation that we haven't really seriously had to deal with since the earliest days of the Republic. And I think that in a lot of ways that explains the hesitancy and the almost bizarre decisions that the Supreme Court made off of the emergency docket this year, where they're manipulating class action doctrine, manipulating habeas doctrine, manipulating the role of equity. There's some very, very bizarre decisions, but when you zoom out, the thread across all of it is that the Supreme Court is actively, desperately trying to avoid taking sides in some of these monumental culture war debates.
I had to tear myself away from what was presently on television this morning, which was the House of Representatives quizzing Ash Patel, the head of the FBI, and then on the Senate side, they were questioning the CDC, regarding vaccines. Some of you younger people may live to see this, but those oldsters won't. What's going to happen to our democratic republic?
I'll let you take that one, Dean Trammell.
Depending on your perspective, I'm either the worst pessimist or the worst optimist, or the greatest optimist, I should say. Maybe the worst optimist. That's probably the best description, which is that I actually don't think that the Constitution of 1787, as largely modified by the Reconstruction Amendments is going to survive all that much longer. Which is to say that we as a people have to decide how we're going to govern ourselves. And when we are just whipsawing between one extreme and the other, it's not going to be a recipe for success. And I think that there have to be very, very significant changes. I don't know if that is in a huge package of amendments akin to the Bill of Rights in the earliest days of the Republic, or if it is essentially a new convention where we sit down and we try to say, all right, what do we have in common? What do we want to accomplish? And unless we're having those conversations, then we're just going to be stuck talking about the filibuster and the Electoral College and stuff that is important, but doesn't ultimately address the core needs of the 21st century. So I'm an optimist on the future of American democracy. I guess I'm a pessimist that it's going to occur within the current framework that we have.
I guess I'm a little more optimistic about the Constitution. I think, I at least hope and pray that this moment is going to pass. A lot of our current crisis centers around President Trump. He has energized one group of people and, pushed another group of people into a rage. But he's also, around 80 years old. He's in his last term. Contrary to what he says, he can't run for office again. He is constitutionally barred. I think it's not going to be too long before he leaves the scene. And I'm hopeful that we will start seeing calmer heads on both sides. I think a lot of the people who are sort of rabid on the left are responding to President Trump, and that when both sides may be able to tone it down and start acting more normal when he's left the scene. I don't know, but I'm hopeful that there may be more of those, dare I say, Federalist Society kind of Republicans and Reagan kind of Republicans. Did you know 2 classmates of mine started the Federalist Society when we were 2Ls at the University of Chicago, 1982. Anyway, that has nothing to do with anything. The problem, of course, today is there's no way you can get any constitutional amendment in this polarized world. 2/3 of the House of Representatives, 2/3 of the Senate, 3/4, that's 38 stinking states, red states, blue states, purple states. Can't happen. You couldn't get a constitutional amendment saying that the sun rises in the east, because if the Democrats introduced it, the Republicans would oppose it, and if the Republicans introduced it, the Democrats would oppose it. And so, if what it takes is amendments or a convention, I think our nation's political climate has to change before we can get to that point. I think the sociological, the climate change has to come first before there's a constitutional or legal solution.
See, like 3 hands in a row up there, maybe 4 that are clustered.
Just generally point and one of them will start talking.
Yeah, y'all start talking.
I got a contribute. So I got to speak a few months ago to a good few judges, including Chief Justice Loretta Rush.
Can you give me a little more volume, please? I'm having trouble hearing.
That's not my strong suit.
Then you may stand and recite.
I got to speak to a good few judges in the past months and have had practices, because that's kind of my career end game, is being a judge. And what they've said is, in the last few months to years, they've seen a lot of disrespect from not just clients, but attorneys as well. And they kind of credit that to the, as you guys said, toxic political climate we're in. And while we're talking about optimism, pessimism with the Constitution, do you think in a calmer environment that there'd be more respect for the rule of law as we kind of simmer down? Or do you think the damage has kind of been done, especially with the flip-flopping of district courts, stopping presidential objectives and how politicized that's become, et cetera?
I don't know that this is mostly a matter of law. To me, the source of my pessimism about our current state of affairs and whether the framework that we have is suited to governing this country of more than 300 million people is that there's this culture of disrespect that seems to be pervasive. But I think there's a root cause to that, which is that so many people feel disaffected. They don't feel invested in the American experiment. And I think in many instances, they feel that way for good reason. They don't see how they're ever going to pay off a mortgage on their house, how they're going to pay off student loans, what any of this means to them. Graduate of this law school, Sherman Minton, very famously said, "You can't eat the Constitution." I think that disaffectedness infuses all aspects of our culture, including the legal culture. And so, we as lawyers do the very, very best we can, but we are not philosopher kings to make it all right. We are. I will often tell my students, the law degree gives you a whole lot of power, and you need to reflect on how you want to use it, not just in the courtroom, not just in terms of your career, but the community that you want to create.
There was almost a direct quote of Antonin Scalia in that, so you be careful, you may lose your ACS card.
I quote Scalia a lot more now that he's dead, but...
My con law professor, by the way. Again, that's dating myself even more. Go ahead.
What do you think are the advantages and disadvantages of class action civil rights lawsuits as opposed to universal injunctions, and why or why not? As in, using a class action lawsuit to provide the injunction and let the government keep doing what it's doing, and unless you identify as part of the group.
Well, the advantage is you avoid the CASA problem. You've got statutory authority if you're working with the class action. The disadvantage, I guess, is there's certain procedural hoops you have to jump through to do a class action. So it's not quite as easy as just walking into federal district court and filing a complaint and asking for an injunction.
One of the things that a number of us have worried about with class actions, because for the better part of a decade, people who would decry universal injunctions will say, well, there's this class action device that proves that this is the superior way to go about things. The concern is that it can take a long time to get a class certified. And so the question is not ultimately, is there a mechanism for resolving a big substantive question at the end of the day? There is. The bigger problem is what happens before then? What happens during the years and years when President Trump can essentially be enforcing a particular policy that would eviscerate birthright citizenship? And class actions didn't seem like they were a great option. But what we have seen is that district judges have actually been issuing class certification decisions pretty quickly. In CASA itself, the district judge said, yeah, there can be a nationwide class. And there was a little nugget that was left in one of the emergency docket decisions this year, which is that classes can even be certified for interim purposes to fill this kind of gap. And it seemed like a throwaway line, and only the proceduralists were really paying attention to it. But Dave Marcus, who's a law professor at UCLA, wrote this short little piece saying, hey, look, the class action actually can do a lot of this work, especially now that they can be certified for interim purposes. I don't think they're a panacea, but I think that that's where a lot of the action is going to be, if you will.
Yeah.
I recently had occasion to reread George Washington's farewell address, and in that, he said that he identified the worst enemy of a free people as parties, and said that a chief despot will eventually prevail over one on the ruins of public liberty. As we approach the 250th anniversary of this little experiment of ours, I wanted to ask you, do you think that George Washington was correct? Are parties the worst enemy of a free people?
I'm not sure it makes any difference at this point. We're not going to get rid of them. I mean, the founders obviously had a different view of how this system of Republican government was going to play out. They didn't really think about parties. Madison writes about faction in the Federalist, and then you end up with a fiasco like Thomas Jefferson being John Adams' vice president because he comes in second, so he spends 4 years trying to undermine the Adams administration. Parties got started very quickly, and I don't see any world in which they're going to go away. So Washington may have been right, but we've got to find a way to deal with the world we have.
I'm going to give a qualified yes, that Washington was right. The qualification is that it's actually not parties, which are just ways of organizing people who can be very, very diverse in their perspectives. It's factionalism. And political scientists have identified a number of indicia that lead to destabilization in democracies. Those are going to include things like massive income inequality, concentration of power in the executive, and very critically, factionalism. Not just disagreements, but where your political identity is entirely defined by a label. And by knowing whether you are a Democrat or a Republican, I can tell you exactly what you believe on basically every major issue. When there aren't these, what again political scientists will call overlapping cleavages, then that's going to be the real problem, where we decamp into these different groups. And I think that we can have political parties, but the current factionalism that we have, the culture war camps, I think could be the death of us unless we fix it.
Some have suggested if we had more of a parliamentary system that would permit a multiplicity of parties, and we do what they do in Israel or England, and you have to form coalitions, that might solve some of this. I don't know whether that's true or not. But
we're being given the red light.
But let's turn it over to the dean.
No red light. A very grateful smile. Please join me in thanking our terrific